From the Library of Congress in Washington, D.C.
So for session 2, we're covering the U.S. perspective, and to quote one of our esteemed panelists, when the protection of moral rights is brought up in the United States, commentators have always emphasized the differences between continental Europe and the United States. And our second panel is going to attempt to explore this unique U.S. perspective. We're going to try not to delve too much into the comparative bit that we already covered in the first panel. So I'll take a moment here to introduce our panelists. I think we're mostly in the order I have. Alan Adler is General Counsel and Vice President for Government Affairs at the Association of American Publishers. And then, let's see, Duncan's next. Duncan Crabtree, Ireland, is Chief Operating Officer and General Counsel for SAG-AFTRA. And then Mickey Ostreicher is serves as General Counsel to the National Press Photographers Association. And then we have Michael Wolf, who is the Executive Director of Authors Alliance. And then Professor Yu, who is Professor of Law and Co-Director of the Center for Law and Intellectual Property at Texas A&M. And there's more information about their backgrounds in your full program. So to get started, as we've talked about a little bit earlier, the U.S. approach is generally described, including in our program, as a patchwork, or sort of a hodgepodge of state and federal law. So to jump in, if you could each say a little bit about one or two of these kind of patches, and I think, Alan, we can start with you.
Thank you. I was very relieved to hear Eric, at the very end of the panel, issue sort of a half-lawyer's disclaimer. I was rather surprised to see 5 lawyers on a panel and no opening disclaimer about whether or not they're expressing views on behalf of a client or employer, so I will do so. And the reason for that is chiefly because when the House Judiciary Committee's process on comprehensive review of copyright law considered the issue of moral rights, they did so in a hearing in which moral rights was one subject combined with copyright term and termination rights, which I think led people to look at that hearing in 2 ways. One of which it was kind of a collective checkoff box to make sure that even relatively obscure issues, as far as the public was concerned, would be addressed in the comprehensive process of review. But also, I think it was a signal that these 3 issues together are issues that, despite any other pretense the committee might make during the process, are highly unlikely to see any kind of reform legislation as a result of the hearing process. And that is in part because I think the issue was largely viewed as having been put to rest during the period that the previous panel discussed in the late 1980s. For the publishing community at the time, they had mustered a sufficient amount of fire and brimstone to help put that issue to rest in terms of legislation. I'll give you just a quick example of the kind of language that was used at the time. Testimony of the AAP before the Senate said that the hearing raises the threshold policy question of whether to superimpose vague, subjective, and wholly unpredictable new rights upon a long-standing, balanced, and successful copyright system. Tell us what you really think, publishers. So I think that that type of view of the issue is one that led us, at least at the AAP, when the hearing was held 2 years ago by the House Judiciary Committee, to look at the issue of moral rights and actually to make the decision that we were not going to submit a statement for the record because we didn't have anything new to say about the issue. When I say nothing new, it's not to say that we don't have anything to say about the issue at all. In the 1980s, we said a great deal about the issue, particularly in terms of concerns, not only that the United States had bodies of law which addressed the issues of integrity and attribution as they appear in 6 bis, but also because we have laws that distinguish the United States from the rest of the world, primarily the First Amendment in our Constitution, which protects freedom of speech from freedom of expression generally. The Congress and the Supreme Court have had no difficulty over the years reconciling the First Amendment with U.S. copyright law, notwithstanding the fact that some view the copyright law as basically restricting what people can do when they choose to use a work of original expression as a form of speech. But nevertheless, it has played a very important role in shaping the way U.S. copyright law has in fact been implemented, and it's also an important bulwark with respect to the issue of moral rights. Because if you look in this country at the issue of defamation law is a creature of both federal law and state law. Primarily, it's a creature of state law, but the First Amendment makes it also, to some extent, a creature of federal law as well, at least when we're talking about public figures or when we're talking even about private figures, but we're dealing with issues of public concern and public importance. So in the area of U.S. laws that were supposed to chime in and count for representing the principles of 6 bis on moral rights, one looked at the issue of integrity and noticed that they talk about the ability to object to any distortion, mutilation, or other modification of or other derogatory action in relation to the said work which would be prejudicial to the author's honor or reputation. The interesting thing about that, in terms of the way U.S. defamation law works, is that the defamation law is probably both broader and narrower in a number of senses. For one thing, the interesting thing about the 6 bis language is that when we're talking about derogatory action that would be prejudicial to the author's honor or reputation, we're talking about derogatory action in relation to the specific work. We're not talking just about general statements that would be viewed as derogatory or defamatory to the reputation of the author. It has to be something that relates to the work that then casts the author in what would be viewed as a disreputable light. That, of course, is not at all true with respect to defamatory law in the United States. The way the law has grown, both as a matter of common law and in terms of state statutory law, it's a civil wrong, it's a tort. It can be either written in the form of libel, or it can be spoken, which would make it slander. It can even be expressed other than by writing or by oral comments. It must be published in the sense that a third party must have seen, heard, or read and understood it to be about the subject and to be damaging to the subject's reputation. If you read the language of 6 bis, it's not at all clear that this can't be a direct discussion between a reviewer, for example, and the author of a work in which the author concludes that the reviewer's comments are, in fact, derogatory in the sense that is contemplated under 6 bis. But most importantly, in defamation law in the United States, the issue of the falsity of the facts asserted with respect to the subject individual who believes that his or her reputation has been harmed is an absolutely critical matter, even to the extent that the First Amendment provides some breathing room for people to engage in commentary and speech that might be viewed as the subject of that commentary and speech as derogatory to their reputation and honor. Unless they can point to the falsity of what was said, they really don't have any kind of action with respect to slander or libel under U.S. law, whereas the notion, I think, of the comparative notion to defamation in 6 bis doesn't address the question of whether what is said contains an element of falsehood. And as we know, we've seen a number of areas where people will engage in what has been referred to as libel tourism to avoid bringing libel actions that really belong in the United States courts based upon the subject matter, based upon the vehicle that was used to make the statements at issue. But people tend to travel to other countries, particularly the UK, to file libel actions there because of the differences in the coverage of defamation and what has to be proven in order to be able to make a case. In most areas of the United States, it's also important that a defamatory statement be one that is unprivileged. In other words, if you are in the situation where you are a witness in a trial proceeding, whether it's civil or criminal, Your testimony is privileged with respect to any character of it that might be viewed as defamatory, because it is part of a process in which what you say is being considered more for its relationship to the particular cause of action or the particular charged offense than it has to do with the character of the particular individual that the matter dealt with. So that's another important element. And of course, as I mentioned earlier, there is this distinction made in U.S. law between how the law treats a public figure and treats a private figure. And generally speaking, as we know, under the Sullivan Doctrine, when we're talking about a public figure, an individual who's an elected official or somebody else who has entered into the public spotlight as far as society is concerned, generally speaking, they have a heavier burden of proof with respect to an action for defamation, whether it's libel or slander, in having to demonstrate actual malice, which is not only that the statements involved were false, but that the speaker either knew they were false or spoke them in reckless disregard for whether or not they were true or false. And none of this is reflected in the language of 6 bis with respect to the idea of harm to reputation or honor. And most importantly, perhaps, in the United States, generally speaking, with respect to defamation, an action for defamation does not survive the death of the subject of that alleged defamation. So you had a very famous case a number of years ago where the children of the noted actor Errol Flynn attempted to sue for defamation of Flynn's character based upon a book that was written, an unauthorized biography of Flynn that alleged that he was a Nazi sympathizer. And of course, the court basically said that those actions, had they been brought by Mr. Flynn during his life, might have had some validity, but they had no validity as far as being brought by those who were his heirs or even his estate. So that's a fairly substantial way in which, even though the notion of defamation law in the United States as it exists serves as a kind of an analog to the integrity rights that are protected under 6 bis, they're really quite different in practice.
Thank you, Alan. Duncan, Alan's covered kind of one way that the right of integrity, the author's reputation, can be protected. Could you tell us a little bit about how publicity rights also works in this area?
Sure, that'd be great. And I'll probably mention the Berne Convention less than anyone in the entire day. If you're thinking, well, I wonder why that would be, in case you don't know, SAG-AFTRA is the union that covers performers, actors, broadcasters, recording artists. And so, as I think was mentioned during the esteemed academic panel before us, largely those individuals have been left out of the Berne Convention, but thankfully there's the WPPT for our recording artists, and there is the Beijing Treaty, hopefully someday to enter into force, for our audiovisual performers. And so, so you won't hear a lengthy discussion of Berne from me, but I would like to just talk for a minute about the right of publicity and its importance, particularly to performers, since that's the perspective that I come from, spending almost 24 hours a day, 7 days a week, 365 days a year around them. I think for most performers, you know, we've had I think for me, a very fascinating academic discussion so far about how the various elements of moral rights, the patchwork quilt, work. For most performers, I think they're more interested in a functional approach to these rights, because what they're interested in is really 2 things, as has been stated by several other people. Number one, the question of how they can protect their non-economic rights, whatever those rights may be, and number 2, how they protect their economic rights. And I would say not necessarily in that order. Depending on the performer, the reality, of course, is making a living as a performer is often the number 1 consideration for most performers. It is a very difficult career to pursue. It is a lifestyle for most performers where fighting for the very basic elements of life can be a real challenge. And so as representatives of performers, for those who have not achieved a high degree of career success, basic elements, and typically compensation, are the number one consideration. And so the right to publicity, as part of a broader moral rights patchwork, is really important, and in fact is utilized. For those who might not be paying attention to it, there have been a number of high-profile cases, litigations that have been initiated seeking to enforce rights under the right of publicity. And I guess I should just say, what it is or what form it takes, at least here in the U.S. From some people's perspective, regrettably, it's not really a federalized right. This is a right that is a sort of common law right that you see in a number of states. Last count, I think around 28 or so states have some form of either common law or statutory right of publicity embodied. There's a few states that are known as being very receptive to right of publicity statutes that have really built a strong framework for individuals and performers, in particular, in my perspective. New York, California, Indiana jump to mind as a few of those. But I do think that it is more than an academic case. There have been a number of cases in the Ninth Circuit, for example, and in other circuits in the U.S. Where various types of performers have sought to pursue economic compensation for violations of their rights of publicity, ranging from commercial advertising types of cases to cases involving particularly video games in recent years. There is, I think, sort of a brand integrity element of this, particularly that you see in these cases that have made it into the appellate process, where we've got compensation on the one hand and where we've got a desire to really use the right of publicity to protect the types of uses that are made of image and likeness of individuals. And that's something that otherwise really you have to rely on a contractual framework to protect outside of that and maybe the Lanham Act, which thankfully I'm not responsible for talking about today. So I think from a performer's perspective, that is a really important option. We did see recently, a very interesting litigation attempting to pursue this type of brand integrity or personal rights protection through a copyright angle, which of course is the Google Garcia case, and prompted, I think, some very interesting writings in the Ninth Circuit level in particular. So for those who haven't checked out Judge Kaczynski's opinion in that case and the subsequent en banc result, you should probably do that. But I think that, from my perspective, that's the type of case that really never should have been brought in the first place, because a lot of us were mystified as to why the plaintiff in that case didn't pursue a right of publicity approach to that issue rather than the copyright approach that was pursued. And so from a practical point of view, again, a functional point of view, that's something that we always try to discuss with our members and our performers, which is to really make sure that they have an understanding, because it is a patchwork, of the various options for seeking to vindicate your rights, and making sure that when you do that, you don't create unfortunate or counterproductive precedents or cause harm to an otherwise precariously balanced system. I think I couldn't wrap up without talking for a minute about the Beijing Treaty. It's something that's very close to the hearts of our members, particularly our actor-performer members. Obviously, our recording artist members have enjoyed similar protections under the WPPT for some time. And actually, when you look at the range of our membership, they speak out very strongly in favor of the Beijing Treaty, both with the knowledge of the specifics of the treaty, which obviously is complex and takes some time to understand, but also from a more fundamental place, which is the really, in some ways, shocking lack of international recognition of performers' rights in the audiovisual space for such a long time, and the joy, frankly, that our performers have setting aside the details at the concept of being recognized in a way that they haven't been so far. And even our recording artist members have stepped up to speak out and say it's not fair that our actor brothers and sisters are not protected in the same way that we as recording artists are at the international level. And so that's something that's really important to us. Of course, the implementation, someone mentioned earlier that the president had sent the treaty to the Senate for ratification, and of course, the implementation package has also been made public. And there are definitely some interesting issues that really, I think, relate to primarily the anti-bootlegging area, which is the focus of the implementation package. That's going to cause some interesting debates. And I think there is some disagreement about the necessity of the scope of the changes that are proposed in the implementation package. But ultimately, it is our hope and desire that moral rights for audiovisual performers get enshrined in international law in a way that's meaningful, both on a detailed and functional level, but also from sort of the philosophical and principled level, to ensure that we would then finally have a broad range of rights for all types of performers, moral rights and economic rights at the international level. So I think I'll stop there. Thanks.
Thank you. And you mentioned your relief at not discussing the Lanham Act. And Eric very helpfully on the last panel summarized Daystar for us. So Professor Yu, if I could ask you to kind of pick up that heavy load and tell us a bit about the Lanham Act and using statutes like that are not copyright law to help protect something like moral rights.
So in terms of unfair competition law, we should start off with Section 43A of the Lanham Act. And so Eric earlier mentioned the Daystar case, and I suspect Professor Ginsberg will also talk a little bit about that as well. And so for Section 43A, we do it offers two different types of protection. The first one is it protects against false destination of origin. So basically, false destination that will cause confusion over origin, sponsorship, or association of the good. And the second thing is about misrepresentation of the nature, characteristics, qualities, or geographical origin of the goods. Right? So from the standpoint of moral rights, the provision will prevent you from providing your name to some other works that has not been created by you, or misrepresenting the nature of the work. So a good example would be the Gilliam case, which in the classroom we usually refer to as the Monty Python case, where ABC took out 24 minutes of 90-minute programming and show it and claimed that it's basically by Monty Python. So when Monty Python saw that, it was appalled by the disjointed format of the programming that's been shown on TV and tried to pursue an action based on both copyright as well as Section 43A. And so with respect to Section 43A claim, that's basically when you're showing the altered version without our authorization and claiming that it's ours, then you are not really presenting a product, but misrepresenting what they have. And so that's a very good example. But I think a lot of the audience members are very concerned about the Supreme Court case, Daystar. In that case, the issue is basically about the TV series that has been put together by Fox and that has gone out of copyright and that has not been renewed. And when they start put together videos, have a condensed version, they slap the opening credits, they change toward the end with the recapitulation and reorder it a little bit and show it in a more condensed version, but just include Daystar right there without mentioning Fox. So when the case went all the way to the Supreme Court, the big issue is whether they will be able to pursue a Section 43A claim based on misrepresentation. And as Eric mentioned early on, what the court look at is basically the origin of the good is the origin of the video, which is the manufacturer of the physical goods. And that's why they're not focusing on the origin of the footage or origin of the intellectual material that has been captured within the videotape. And I think there are two different readings, and I think a lot of the commentators, a lot of the lawyers have been debating as to how broad you're going to read the Daystar case or how narrow you're going to read it. I think the broad reading is that we focus on the physical goods, and you will not be able to claim any false destination of origin based on the content inside the physical good. right? So that would be a very broad reading of Daystar case. But I'm more in line with the camp that has a more narrow reading. And a more narrow reading is that if you look at the case, it's about public domain material that's already gone into public, that's not protected anymore. And if you want to go even deeper, you can see that a lot of the footage is actually from the Allied forces. And so it's not even from Fox, right? So you have a lot of different ingredients that will actually lead the court to say that, well, if you look at the origin, then there's no need to actually credit Fox, especially when it has gone into public domain. So that's one way to look at it. And then I also know a number of commentators have actually separated non-attribution from misattribution. So non-attribution is basically you do not include the name to the footage, and in this case, footage that's already gone into public domain. And misattribution is basically similar to the Gideon case, where you actually put somebody else's name or you have altered the state of the footage, and then you claim that it's the original. And in the Daystar case, I think it goes closer to non-attribution, but not so much to misattribution. So had the Gilliam case been put forward before the Daystar court, I guess the outcome may be somewhat different because of an altered state. But I think the concern for a lot of commentators is that after the Daystar case, there are also a lot of lower courts that are trying to apply the very broad reading of Daystar and showing that there will be very limited protection under Section 43A in terms of the attribution interest within the intellectual work. And I think that has caused a concern for a lot of those people who want to have stronger moral rights protection.
Thank you. Keeping on the attribution track there, earlier in the first panel there was mention of some of the newer WIPO treaties, and of course those include Protection for Rights Management Information, or RMI. So Mickey, could you talk to us a bit about RMI protection as a way for protecting moral rights?
Sure. With my press background, for those of you who are not connected to the internet right across the street, I'll let you know that the Supreme Court denied cert in the Google case, the book case. So I think that's something people will be talking about today in our area. But that breaking news aside, earlier somebody talked about it really wouldn't make any sense to publish a book without somebody's name on it. And yet, with hundreds of millions of images being uploaded almost daily, we are seeing all those images, for the most part, without somebody's name on it. And the rights management information is critical to at least visual journalists and visual creators in terms of doing that. So attribution information under moral rights. The problem under moral rights that they have is that it's very narrow in terms of it's got to be for exhibition, it has to be numbered, no more than 200 works, more than 200 copies made, and for the most part, those visual images in terms of photography will not fall under those protections. So what else can we do? And then we have a number of, now we get into all the acronyms, and again, standards for rights management information. There's copyright management information, CMI, and that's codified under Section 1202 of the DMCA. And we can talk about that. I'm not sure if you want to talk about that now or when you go to the next question. Then we have IPTC and EXIF and then PLUS, and we don't really just yet have a standardization in terms of how we are going to allow the people that create visual works to have that attribution, whether it's information just about them, and even when there's information there that will help people identify who it is that created that work, oftentimes that information that is referred to often as metadata is stripped out of that, the visual works, and we have pretty much almost instant orphan works, if you will. For an image that could have been created only moments ago, when it goes up on the internet and is seen around the world, somebody may not know who it is, and oftentimes these images are being used without permission or credit or compensation. And that really is a huge problem. You were talking about performing artists. In terms of visual artists trying to have and earn a living doing what they do in this brave new world of so many millions of images being out there, that's a dilemma that we are truly faced with. So, under DMCA, there's certainly a number of really better protections as far as we're concerned. The real question is going to be then enforcement, and that seems to be a big challenge for everybody in terms of what they're dealing with, setting the standards and then enforcing them. So I think maybe as we get into some more questions, I'll get into more specifics.
Great, thank you. And you mentioned a little bit there how dealing with photographers is different than other types of visual arts, and we've talked a little bit about VARA in the first panel as well. Professor Yu, was there anything you'd like to add on VARA that you feel we haven't covered in either of the panels so far?
So we touched on VARA a little bit. I think this is actually a topic where most people are quite familiar. So the Visual Artists' Rights Act, which was adopted in 1990, covers 3 different types of rights. One is the attribution right. The second one is the integrity right. And then the third one is basically the right against destruction of works of recognized stature. And so when you look at the comparison, I think Daniel Gervais talked about VARA in the context of the Berne Convention. You can see that we actually offer more protection in terms of the right of against destruction of works of recognized stature. And I think that type of right, you can describe that as closer to right of destruction or right of integrity, but you can also make a good comparison to a lot of our state art preservation laws. So in California, in New York, in a lot of places. And so that's more like a hybrid. And if I have to describe that, I would probably call this as moral rights with US characteristics. With respect to the Berne Convention, I think the main concern for a lot of people is basically we are narrowing the scope of the protection. So the protection is only limited to a very limited category of works. So that would be paintings, sculpture, prints, and drawings. And so even with in those categories, they would have more conditions attached to what you have. So a good example will be photographs. As we just heard early on, we will have limited to the number of copies. So a single copy or 200 or fewer copies. And then after that, you also have to be signed or consecutively numbered by the author. And then at the very end, you also have the purpose. It has to be for exhibition purposes only. And so there are actually case law talking about what would actually cover within that particular phrase. So you can see that it has been very narrow. And I think in terms of protection, that's also more narrow than what we have in the Berne Convention. In the Berne Convention is usually life of the author plus 50 years as the standard, and in the US we have life plus 70. But when you look at the Visual Artists' Rights Act, it's basically life of the author, and that's basically stopped right there. And so it's not really in par with the duration of copyright, but it's actually shorter than that. And so I think with respect to the Visual Artists' Rights Act, what's interesting is that we try to come up with something that is quite unique for us and that's also acceptable at that time, but at the same time, it doesn't fit very well in terms of both the Berne Convention as well as the scope of protection we got in both the right of attribution as well as right of integrity.
Thank you. At the end of the last panel, Ms. Devora mentioned that, in her opinion, most of this should be covered by contract law. Alan, could you tell us briefly a little bit about how contract law can play into this, and then we'll turn to Mike and hear about some specific types of contracts.
Yeah, the notion of contract law was also one of the reasons why publishers generally objected to the imposition of a layer of moral rights on top of the existing economic rights and property rights framework of U.S. copyright law, in part because they felt that contracts gave the parties both a great degree of flexibility in terms of how to develop and conduct their own relationship with respect to the publication of a work, but at the same time, in addition to that flexibility, once a contract was in place and had been fully negotiated, it also added a great deal of certainty and predictability about the way in which the relationship would continue, and the work at the center of that relationship would be dealt with. There is, of course, as has been said, there's no attribution right in U.S. copyright law specifically, but that's an issue that is typically dealt with under contract. Many works in the United States are published either pseudonymously or anonymously, and that's generally dealt with between the author and the publisher as a matter of contract. And the courts, of course, generally tend not to try to read between the lines of a contract unless it's absolutely necessary to do so. So it's the express language of what's within the four corners of a contract that ultimately shape the relationship of the publisher and the author with respect to a particular work, and how copyright law is implemented with respect to that specific work in the context of that relationship. One of the curious things that we see, though, is that sometimes I think that there is a situation where the notion of a contract, or at least the way licenses are used today, can put the issue of attribution and integrity in opposition to each other. I'll give you one example. There is a pending rulemaking at the Department of Education called the Open Licensing Rule, in which the Department of Education is trying to encourage the creation of open educational resources through its direct competitive grant program. And as a result, what it wants to do with the rule is impose the obligation on any grant recipient that any copyrightable work that they produce with grant funds from the department would have to be available publicly as open educational resources, basically subject to the equivalent of a Creative Commons attribution-only license. The problem with that is that because they essentially say to the individual that if you receive federal funds to create a work, that work not only is going to be subject to various kinds of adaptation and repurposing and alteration by other parties down the line, but at each instance, they say, because they determined when they developed Creative Commons licenses that most people did at least want to have attribution as a requirement of the transaction, they require that at each stage of that process, attribution to the original author be made. And what that means is that you're going to have a circumstance where, as a result of that kind of license agreement, as a result of receiving federal funding and the contract terms for that funding, you're going to have the situation where an individual author continues to be credited as the author of a work after it has been substantially altered, repurposed, adapted in ways that that author might find absolutely appalling and completely at odds with their original purpose in publishing that particular work. So contracts can do a lot of things. They provide flexibility, they provide certainty, they allow the parties basically to decide their own fates within a particular transaction. Now, we have heard on occasion that one of the reasons why moral rights needs to cut into that kind of flexibility and freedom of contracting is because frequently the bargaining positions of the parties, in my field it would be the bargaining position between an author and a publisher, are unequal. Well, they can be unequal, but in two very different directions. A very well-known author with a very long track record of success in publication typically will have more leverage than the publisher will in determining the transactional terms of the next publication if that publisher wants to become the publisher of the author's next work. Obviously, the situation is reversed when you're dealing with an author, either a first-time author or an author who has developed a little public reputation and little record of success in publications with previous authors or previous publishers. So you find the situation where contracting is something that is more conducive to the U.S. system. It seems to be something that in civil code countries has to be cabined within the terms of civil law. And that was one of the reasons why publishers continue to feel that a moral rights regime with that kind of European flavor would basically be detrimental to the way copyright has served the interests of this country.
So Mike, Alan mentioned Creative Commons licenses, and they're something that have sometimes been talked about by scholars as potentially being America's moral rights. Could you share some of your thoughts on that, and then also on the role of extra legal norms in the area?
Yeah, absolutely. So, Creative Commons licenses, which I'm sure many or all of you are familiar with, are a suite of public licenses designed to allow the widespread sharing, in some cases reuse and remix of creative work. And as Alan just recently mentioned, one of the, or the essential condition of a Creative Commons license is in fact an attribution requirement. So every license takes the form of usually a hyphenated string of 2-character abbreviations. A CC BY would be the CC attribution license, and that can be amended by selecting from a menu of options any of a number of different requirements. The licensor can elect to not to disallow derivative works, or to require that that creators of derivative works share them under the terms of the same license in a share-alike license, or that require that any use of the work be non-commercial, or any downstream use of the work be non-commercial. And I would, just to back up and respond a little bit to one of Alan's comments about open educational resources and the use of a bare CC BY license and its impact on specifically the right of integrity. It is important to note that if it is a CC license, that CC licenses also provide to some measure for a right of disassociation, and it would be a flip, a little bit of a flip of the default, but where a work is modified in such a way that the author no longer feels comfortable having their name associated with, the CC license standard terms do require that a downstream user remove the name where reasonably practical, the name of the original author where reasonably practicable. These are an interesting solution. I wouldn't call them an American solution entirely. They are American in origin. Creative Commons is originated in the United States. But it is a global licensing scheme, and it's designed to be global and portable. To that end, the CC licenses provide for moral rights, and in fact, while all of the licenses have a provision that waive moral rights, but only to the extent necessary to reasonably effectuate the license, and only where actually waivable in the jurisdiction. There's an interesting question of how and whether in attribution by license is equivalent to a moral right of attribution overseas. It seems to me that not only is the attribution right an effective tool for providing the recognition that many authors who use Creative Commons licenses specifically are seeking to garner through their work, that the CC licenses also tackle some of the more fiddly aspects of what it means to have an attribution regime in an online environment. And this is a lot of what Mickey was talking about with regards to rights management information. But merely having the name of the author associated with the work seems today to be somewhat insufficient for the purposes of having the author be properly credited. To that end, CC is also a scheme, a digital recognition scheme, where there's a cascading amount of copyright management information pointing both to the author, any attribution parties specified by the author, the copyright notice, the terms of the license itself, which are available on a standalone website that is easily linked to and findable. A notice refers to the disclaimer of warranties, and a URI or a hyperlink to a specified place where the information resides on the internet. And given how easily rights management information can be stripped, it isn't necessarily a complete solution to the realities of online attribution, but it takes the problem seriously and does so in a way that's readily accessible to any user of the Creative Commons suite. And there's also the interesting effect of having, of encouraging attribution beyond the scope of copyright. So even though the Creative Commons licenses are do not purport to be broader than copyright, they allow for the fair use exception and any other exception or limitation that the Copyright Act provides. They still nonetheless encourage by taking advantage of most individuals' risk aversion, compliance with their terms. So in the instance of overcompliance, CC licenses in some way suggest and recommend attribution even where perhaps not absolutely required by copyright law or by the license itself. Moving on, I'm actually going to segue directly into a topic that's not entirely directly related, and that's how extralegal norms stand in place of moral rights in the United States. So there is, as the panel has discussed, a significant patchwork of rights that to some extent, if not completely, provides something akin to moral rights protection to American authors and authors in the United States. But the reality on the ground is substantially wider, or just based off of norms and practices within communities, and particularly around the norms of plagiarism, which is what I'm going to focus on today. Plagiarism, which comes from, I think the Latin root is from kidnapped or kidnapper, is a extralegal norm independently defined in various communities of practice that cautions against and provides often extralegal remedies against uses of works that are in some way fraudulent or unauthorized. And generally in the sense of not including attribution information that we take to be an essential part of the right. There isn't an identity with infringement here. And if you think of the way I've been trying to consider the topic is viewing the possible areas of wrongdoing as almost as a Venn diagram where infringement, attribution, a right of attribution and plagiarism are all mutually overlapping, and characterizing the problem that way, there is a significant portion of the attribution right that might cover what today in the United States is plagiarism, or what might not be plagiarism at all, but is nonetheless not copyright infringement either. So plagiarism, I've sidetracked myself a little bit. And there are, one of the virtues of having an extralegal norm as opposed to a formal statutory right, although I won't draw any conclusions as to whether this affects the propriety of having a statutory right, is that within various communities of practice, there can be and in fact are different approaches to the question of plagiarism. In the case of literary works, academia has very strong norms about plagiarism, not all of which are necessarily entirely consistent with what we might think of as attribution for a work. If a research assistant provides significant contributions to a paper, the fact that their name does not appear on the text will not generally be considered plagiarism or in violation of the norms of plagiarism, despite the existence of the contributions. Meanwhile, for student works, there are the taking of unattributed sources is a serious infraction that can result in expulsion or any number of academic disciplinary measures happening within the case of a school. Whereas in creative writing, attribution, while considered a requirement, and there is a very strong norm of plagiarism, might not take the same way as a formal academic approach to credit. So rather than footnotes or citations, you might have something like Jonathan Latham's excellent essay, The Ecstasy of Influence, which is subtitled A Plagiarism and composed entirely of plagiarized sentences, all of the sources of which are credited, in a sense, by being listed at the end, but not in line or and not in quotation marks with ellipses in the way that lawyers are very familiar with, in a way that would meet the norms of academic scholarship. And in film, even in the Daystar case, that was acknowledged in that opinion by Justice Scalia to be an effect of plagiarism, and for Fox's purported remedy essentially to be an action for plagiarism. But plagiarism only extends in many cases as far as norms allow. And today we have contracts will usually negate some of what we would consider plagiarism or a violation of attribution right in the sense of a ghostwriting contract allowing for only the purported author's name and not the ghostwriter's name. And I've completely lost my train of thought, so I'm gonna wind it down there.
Thank you, gentlemen. I know there's a lot more to cover. We have just a few minutes left for questions from the audience. Where are my mic runners?
Great, thank you. I want to take exception to a comment that my friend Alan Adler made. I don't always disagree with Alan, but Alan stated, and I think I'm paraphrasing, contracts give flexibility and certainty as to how work would be dealt with. Well, in my experience, my previous life at ASMP, at the Trade Association, over the years, the one thing that we could be certain regarding most textbook publishing licenses and contracts was that they were being exceeded. There was no certainty that the terms of the contract was being upheld. So, and I agree with you, the leverage issue, I'm not sure that, I think that tilts still more in favor of the publisher than the number of, I guess, authors that have significant leverage over a publisher, I think is significantly less than the number that don't. But as far as contracts were concerned, I don't think they gave any particular certainty as to what was happening with the future of a work.
Well, I guess let me try to clarify that, Gene, because what I meant, and I think you've affirmed this, is that the terms of the contract create certainty. Now, whether or not the terms are complied with is another question, and the fact that you are able to point out in a given situation that the facts of implementation of that contract don't match the terms indicates that there is at least the possibility and the intention of certainty. It simply isn't followed through in terms of performance. So I think that you still have the notion that contracts are useful for providing certainly the aspiration towards certainty and predictability, but you're still dealing with the question ultimately of whether or not the performance will be faithful to that aspiration.
Then we still almost agree.
Danielle?
It's also for Alan, and also on contracts. So you underscore the almost sanctity of contract, right? So important. Yet the United States has something that authors in other countries envy us, which is the termination of transfers, which seems to be a little bit of government interference in the contract. And I understand that some of the workarounds, especially that some lawyers in Nashville have tried for termination of transfers, have not all been tested in court, but it's a pretty strong, unwaivable, untransferable right. Is that un-American?
I think, as you probably would agree, Daniel, that's the exception by far, rather than proving the general rule of the way in which freedom of contract is generally allowed to operate within the copyright system, and more importantly, drives the copyright system increasingly because of the increasingly broad role that licensing of the use of works plays. We're seeing within the context of the current copyright review this battle play out between those who are advocating the importance of continued certainty and definition with respect to ownership of rights with respect to particular work, whereas we're also seeing a society that is increasingly content simply to have access to use the work, is not really interested in ownership because of the other attributes that ownership usually has, which requires maintenance, storage, care, things of that nature, upgrades, whatever. So I think that I wouldn't point to the exceptional circumstances as generally vitiating the rule, which I think continues to be that contract plays a very important role. I mean, one point I would also want to make here is that, we talk about the integrity with respect to the issue of its match under U.S. copyright law with respect to the right to control the production of derivative works. But there's always going to be the question of what actually is derivative. At the far end of the spectrum, I suppose it's possible that using the common understanding of the word derivative, a work can steal completely the ideas of a prior author's work, but not, of course, be actionable as copyright infringement because it doesn't take the original expression. So you have to have a notion of these legal concepts that is susceptible to clear definition. It's always going to be the case that we're going to have litigation because, as June mentioned, we are a particularly litigious society, and we'll always be trying to game the fringes and the edges of these rights. But today, for example, we're seeing the discussion of whether or not remixes and mashups are vitiating a derivative right. If that's true, I don't know that anybody has related the question of remixes and mashups to moral rights at this point, but it certainly seems to be that that's another avenue to be explored.
Actually, before we go on to the next question, just say I think one of the topics we didn't discuss, but is thinking about the importance of contracts with collaborative works and how a lot of challenges would exist in the absence of the prevalence of contracts for collaborative works, like in the audiovisual area, because how you would coordinate and harmonize different participants' different moral rights and other rights without contracts would be quite a complicated scenario.
Yeah, in fact, Eric's history of in the late 1980s, at the time of Berne implementation and immediately thereafter, left out the fact that in the hearings that were held about moral rights, the other main issue being discussed was the impact of moral rights on the work for hire doctrine, and particularly because the Supreme Court had just decided the Reed case. And at that point, there was a real question as to whether or not it was possible to create a situation in statutory copyright law that would accommodate that notion as the Europeans have it, but still be consistent with the way the Supreme Court interpreted the work for hire doctrine, which depended greatly upon the way in which a written contract essentially defined the relationships of the party.
Great. Thank you, gentlemen. I'm afraid that's all the time we have for this session. We have a short break until 11:20, and then we'll have our keynote. And for those who are standing, there is room up in the front and in the middle, so please do feel free to fill in during the break.
This has been a presentation of the Library of Congress. Visit us at loc.gov.